Hello and welcome to today's episode of Justice Bytes, a series where we look at the way that Maurice Blackburn is making a difference in the community. I'm Jennifer Canis and I look after the team's social justice practice. Today I'm joined by Bridie Murphy, a Senior Associate of Social Justice Practice. Welcome, Bridie.
Thanks, Jen.
Bridie, we recently had a client come in with a fairly unique problem. What was it?
Matthew Roberts is a self-employed sex worker operating in Victoria, and he came to see us because his application for an EFTPOS machine and related payment processing services, which he wanted to use in his business, was declined because he is a sex worker.
What's the impact of that on Matthew?
He reported that approximately 50% of his clients use EFTPOS and other payment processing facilities to pay for services as opposed to cash. So immediately that creates problems for him operating a business and his financial security.
And I've often heard the term debanking. That's relevant in this case, isn't it?
It is. Debanking generally refers to when financial service providers remove their services, whether that be access to a bank account or related facilities like an EFTPOS machine, across entire industries, as opposed to making that assessment on a case-by-case basis. And what happened to Matthew in our case could be referred to as debanking because he was declined access to financial services because of his occupation as a sex worker.
And this is a very recent case that's been run. It resolved out of court, but my understanding is that this case has only been able to be run because of some changes in Victorian law. What have those changes been?
In 2022, there was a suite of legislation introduced in Victoria decriminalising sex work, and that included amendments to Victoria's anti-discrimination legislation, the Equal Opportunity Act. Those amendments included that it is now unlawful to discriminate against someone on the basis of their job, and that's particularly important for sex workers because it means if they are subject to discrimination, they can go to the courts and seek some kind of remedy for that.
And so was the argument in this case that our client was discriminated against because of his occupation?
We were arguing that Matthew was discriminated against because of his occupation as a sex worker, and that discrimination was comprised of refusing his application for an EFTPOS machine and payment processing services.
Now, I know when you're bringing cases for new law that sometimes there's lots of hiccups along the way. And I think that with this case, it was the first case that had really tested these new Victorian laws. How was that to be involved in that sort of new law testing?
It's always really challenging, but really interesting when you're working in a new area of law. There were some other cases that were commenced around the same time as Matthew's, quite quickly after these new laws were introduced, which shows that it is a kind of problem that many people were facing. But there wasn't any established precedents that we could look to in Victoria for guidance on how this case should run or where we should be and what we should be arguing.
How do financial institutions justify this type of discrimination?
Often we've seen that financial institutions will refer to a concern about risks inherent in sex work and other industries, and the obligations they have under a variety of legislation and regulations about their conduct. That includes the Anti-Money Laundering and Counter-Terrorism Financing Act, which provides a pretty broad discretion and exemption from discrimination laws if you are seeking to comply with that act.
But the discrimination laws are pretty clear that they shouldn't be refused financial services.
That's right. We would say the discrimination laws are clear on that, and to the extent that companies have other obligations and risks, they should still be seeking to comply with them and their obligations under discrimination laws. And I think what we would say the balance to be struck there is about not applying blanket bans to entire industries. Really, they should be looking at every application on a case-by-case basis, and where that application is coming from a state that protects discrimination on the basis of occupation, they should really ensure that they're not declining those services because someone has a job as a sex worker.
So this has been quite a technical case to run, but it's had a real impact on your client, hasn't it?
It has. Matthew's really happy with the outcome that he's been able to achieve in this case. In the settlement, he was able to get a commitment from the two companies involved that they will no longer apply a restriction on services to sex workers, that they will assess the applications made by sex workers on their merits, and that their staff involved in assessing those applications will undergo training about their obligations under the Equal Opportunity Act. That obviously has an individual impact for Matthew, but it has a broader beneficial impact for other sex workers because they now know that there are these two organisations or businesses on the record saying that they will consider their applications, and those commitments are Australia-wide. That's important because not all states and territories do prohibit discrimination on the basis of sex work, so it provides an additional layer of certainty beyond what's currently legislated.
The changes that were made by the Victorian government to the legislation, why were they necessary?
The changes were necessary because for a very long time sex workers have been subject to really high degree of regulation in the work that they do, and that I think has fed into a degree of stigma around the profession and that it isn't, entirely lawful or legitimate. I think that community values have long moved past that and recognise this profession as one not very dissimilar to any other and that deserves the respect, rights and entitlements same as any other job. The changes to the law in that regard were meant to remove that association with sex work as a criminal act and to ensure that people engaging with it weren't subject to discrimination or any other kind of mistreatment, and to make clear that sex workers' rights are workers' rights, the same as anyone else.
And why was it important to run this case?
It was important to run this case for the same reasons it was important for those laws to come in. I think that unfortunately still there is a stigma associated with sex work, and whilst we know that sex workers' rights are workers' rights, that is not always the way sex workers are treated in the community. It was important to send a message to businesses that were engaging in these practices that that is no longer lawful, that they should be taking applications from sex workers on their merits and not discriminating against them on the basis of that job.
Bridie, this has been a bit of a difficult case to run because it's so new. What motivates you to run these difficult matters?
I think it's really important for us to take on cases like this because they are really difficult, they haven't been done before, and often they involve people that aren't going to have the resources to do this without the assistance of a pro bono practice and law firm. And it's a really important access to justice point. This is an important issue. Sex workers' rights and entitlements are the same as everybody else's, and so we wanted to make sure that they were being enforced, that this legislation was being brought to the community's attention, and it was a really worthy cause for those reasons.
Thank you, Bridie. It'll be interesting to see what happens in other states and whether any other financial providers follow the lead now that we've achieved here. If you'd like to hear more about this case and some of the other matters that are run at Maurice Blackburn, please check out our social media and our website. And if you'd like to hear more one-on-one stories with our lawyers, please continue to watch Justice Bytes.